The CARES Act intends to distribute more than $2.2 trillion in stimulus funds. Federal regulators and the Department of Justice have already announced that they plan to aggressively root out corruption and fraud within the system. One tool that they'll have to use is the False Claims Act and the whistleblower protections that are associated under that statute. My name is Marisa Darden. I'm a principal in the Government Investigations and White-Collar Crime section at Squire Patton Boggs. I was a state and federal prosecutor before joining Squire Patton Boggs, and I'm going to talk more about the False Claims Act. So what is the False Claims Act? It's actually a tool that's been used by the government for over 150 years to reclaim losses as a result of fraud or fraudulent activity against the government. It's often used in the healthcare space, but it can be in any sector where public funds are disseminated and or used. Some common examples would be programs that take money for Medicare or Medicaid, hospitals, any public-private partnership, and other organizations that take grant money or federal loans, including the CARES Act money, this $2.2 trillion stimulus package recently passed by Congress. Looking now, coronavirus-related concerns could include things like companies that are selling deficient or substandard personal protective equipment, an enforcement action related to electronic health records or other personal identifying information related to patient care. And hospitals and other entities should also be aware of investigations relating to patient care, management of systems and funds, research issues, or other areas of concern where a government would have an interest in protecting patients or other individuals. So the interesting thing about the False Claims Act is that there really is no scienter or knowledge requirement in order to be prosecuted. In other words, the government does not have to prove that the company or the executives being prosecuted actually knew that there was a fraud perpetrated against the government. It's simply enough to recklessly disregard the signs or to be involved in something where the eventual result was a fraud against the government. And also, damages can be very steep under the False Claims Act. In many cases, companies who are fined under the False Claims Act have to pay triple the original amount that was defrauded. Under the False Claims Act, the qui tam provisions, which is really just a fancy word for whistleblower or relator, are some of the provisions that people hear and think about the most when they think of the False Claims Act. Essentially, when someone knows or learns about some alleged wrongdoing, they can file their own relator complaint suing on behalf of the wrongdoing or behalf of the government. Eventually, the government must notify the court as to whether they intend to pursue the relator's complaint and move forward in prosecuting or decline to investigate it further. One might wonder why a whistleblower would go through all of this effort or put themselves at risk in order to do this on behalf of the government or some potential wrongdoing. And the way that the False Claims Act keeps the incentives high is to create a monetary value. So if a relator's claim eventually is found to recoup losses from the government, the relator themselves can recoup up to 15 to 25% of the total monies recovered, which could be millions of dollars. The most important provisions under the whistleblower portion of the False Claims Act statutes are the robust protections afforded whistleblowers in the workplace. The statute protects the whistleblower from being retaliated against, discriminated against, or otherwise harassed as a result of their complaint. It's increasingly common to see whistleblower complaints pursued through a prosecution and to an end result. In fact, last year, the Department of Justice recouped about $2.5 billion from the healthcare industry alone in qui tam relator complaints. Some suggestions include having a top-down leadership approach that emphasizes open communication and robust compliance with the rules and regulations of your industry. Most importantly, document, document, document. Don't assume that your normal procedures and practices will capture the why or the how. Implement and sustain an effective compliance program that encourages cooperation and open dialogue amongst entities and groups. If individuals feel compelled to report information, they need to feel comfortable doing it within the organization first, so that key individuals can participate meaningfully in assessing the problem, rooting it out from within, and doing something to fix it before government intervention takes place. I'm Marisa Darden. Thanks for watching Talks on Law.